Thank you, Mr. Chairman. Obviously, there's a lot of passion in the room, and that's for good reason. Everyone here is frustrated, and I think you're frustrated as well, because we now, the answer to almost every question is we have to play the hand that we are now dealt. So rather than beat a dead horse, I'm going to see, looking for the future, is there a way that we don't get dealt this hand again? So I have two questions for you. First of all, one of the reasons why I believe we're in this boat that the taxpayers, quite frankly, are paying for is because the individuals who are spending this much money on defense have entered into a settlement whereby they had no admission of guilt. So the first question is, could we have avoided that by not entering into that settlement? And then number two, who made the decision to go with conservatorship as opposed to a receivership? And can you explain what boat we would be in now had we been in a receivership and not a conservatorship?
With respect to your first question, Congressman, the determination to reach a settlement agreement with the three former officers was something that was a decision that was made by the then director of OFEO. It was done based upon the facts and circumstances in which, he was operating at this time, and that was not my decision, and but I believe that he had solid grounds for his determination at that point, but that was done at that time. With respect to the decision of conservatorship versus receivership, believe that has been described at some length by the participants that were involved in that decision at the time. That would be principally Secretary Paulson and FHFA Director Lockhart, about the determination of what form of intervention the government would take, with Fannie Mae and Freddie Mac being removing from the market and having their access to the capital markets rapidly being withdrawn. And the issues there are far broader than the immediate matter that we are talking about here today regarding certain litigation. And the determination was that it was necessary for the goal was it was appropriate to provide government support in using the vehicle of conservatorship, because there were grounds to appoint a conservator, and there was a public policy goal of assuring that the country maintained a functioning secondary mortgage market right at the point that the whole U.S. financial system was teetering on the brink. And so that was a determination made at that time. I believe it was the right one, and it was done for reasons that are far broader and have far more far-reaching implications than the particular matters of litigation that we're discussing today, sir.
Understood. But it still leaves, one of the problems that we have here is that overall, this is the exact reason why the general public doesn't trust the government and doesn't believe that we ever have their interests at heart. What we have here is three individuals that we know have abdicated their fiduciary responsibilities at a minimum, and in doing so caused a tremendous amount of harm to the markets and to the taxpayers. And because they were able to enter into a settlement where they didn't have to admit any guilt, the taxpayer bears the second burden. That frustration is overwhelming, and I have to believe there's a better way, and there has to be a mechanism that when we look at these types of settlements, and when we decide whether, and I understand it's a very complicated issue between conservatorship versus receivership, I understand that, but when you break it all down and get past all the legal jargon, I have to believe there's a better way than leaving the taxpayers constantly holding the bag. So I leave you with the thought that when we're entering into settlements, in this very unique situation where there is almost unlimited liability to the taxpayers, that has to be part of the decision process in entering into these settlements. Thank you.